Most small businesses are built on a foundation of hard work, good instincts, and relationships. The legal documents that are supposed to support that foundation are often the last thing anyone thinks about until something goes wrong. Hi, I'm Michael Harman, a North Carolina employment lawyer, and I want to walk through the essential employment documents every small business needs to have in place. What they are, what they need to say, and what the absence of them can cost a business when a dispute arises. The Employee Handbook. The Employee Handbook is the document that governs the day-to-day relationship between your business and everyone who works for it. It sets expectations, establishes policies, and creates the framework that everything else in the employment relationship is measured against. A handbook that is working for your business covers the at-will nature of the employment relationship explicitly and correctly. It outlines your policies around conduct, attendance, leave, and workplace behavior. It describes your harassment and discrimination complaint process in enough detail that employees know exactly how to raise a concern and what happens when they do. And it's reviewed and updated regularly so that it reflects how your business operates today, not how it operated when the document was first written. A handbook that's working against your business is one that was pulled from a template, never reviewed by anyone with legal knowledge, and it's been sitting in a drawer since the business opened. Outdated policies, vague language around termination procedures, and missing at-will disclaimers are the most common problems, and they surface at the worst possible time, which is when a dispute is already underway. If your handbook describes a specific progressive discipline process and a manager skips a step, the business may have created an implied obligation it didn't intend. Consistency between what the handbook says and what the business does is what gives the document its legal weight. Offer letters and hiring contracts. The offer letter is the first legal document in the employment relationship and one of the most frequently underestimated. Most small businesses treat it as a formality, a quick confirmation of the title, the start date, and the salary. The language in the letter deserves significantly more attention. A well-written offer letter clearly states the role, the compensation structure, the start date, any conditions attached to the offer, like a background check or a drug screening, and the at-will nature of the employment relationship. For the new hire, it removes any ambiguity about what they are walking into. For the business, it establishes a clean and documented starting point with no unintended promises buried in the language. Where offer letters create problems is when the language implies more than was intended. Phrases like permanent position or long-term opportunity suggest job security that was never meant to be guaranteed. Describing a salary as annual rather than a rate could imply a guaranteed year of employment. Outlining conditions under which someone can be terminated, even with good intentions, can create an implied process that the business is expected to follow every single time. For roles that involve access to confidential information, client relationships, or proprietary systems, a more formal agreement may be appropriate. That document can address confidentiality obligations, intellectual property ownership, and non-solicitation provisions in a way that an offer letter is not designed to handle. The key is matching the document to what the role requires, not using a one-size-fits-all template for every hire. Independent contractor agreements. Independent contractor agreements are one of the most misunderstood documents in a small business's legal toolkit. Many business owners believe that having a signed contractor agreement in place means the classification question's settled, but it's not. The document matters, but what it says has to reflect the actual nature of the working relationship. A contractor agreement that describes genuine independence, like the contractor sets their own hours, uses their own equipment, works for multiple clients, and is engaged for specific deliverables, is a document that supports the classification. A contractor agreement that describes what is functionally an employment relationship, but labels it as contracting, doesn't protect the business when a classification dispute arises. North Carolina uses a multi-factor test to determine whether someone is truly an independent contractor or a de facto employee. The IRS uses a separate test, but both look at the reality of the relationship, not the label on the document. A business that's been classifying workers as contractors without a written agreement, or with an agreement that doesn't reflect reflect how the work actually functions is carrying significant exposure in the form of back payroll taxes, unpaid overtime, and workers' compensation liability. The contractor agreement needs to be paired with a working relationship that actually supports independent contractor status. Both the document and the reality have to align. Wage and hour policies. Wage and hour violations are among the most common and most costly employment law mistakes small businesses make, and most of them stem from the absence of a clear written policy. Federal law under the Fair Labor Standards Act and the North Carolina Wage and Hour Law govern how employees must be paid, who qualifies for overtime, and how pay practices need to be documented. Most small businesses know they have to pay overtime for hours over 40 in a work week. What catches them off guard is the exemption question. Not every salaried employee is automatically exempt from overtime. The exemption depends on the employee's actual job duties and their salary level, and misclassifying a non-exempt employee as an exempt one is one of the fastest ways to accumulate unpaid wage liability. A written wage and hour policy that clearly defines the work week, establishes how overtime is tracked and approved, addresses meal and rest breaks, and outlines the pay schedule creates a documented framework that protects the business when a pay dispute arises. Without it, disputes become a matter of one person's word against another's, which is never a position a business wants to be in. Severance and separation agreements. When an employment relationship ends, whether through termination, layoff, or resignation, a severance or a separation agreement is often the document that determines what happens next legally. A well-drafted separation agreement accomplishes several things at once. It confirms the terms of the departure, addresses any outstanding compensation or benefits questions, and in exchange for a severance payment, releases the business from legal claims the departing employee may otherwise bring. That release is the core function of the document, and it's only enforceable if it's drafted correctly. A separation agreement that's too vague, that fails to comply with specific federal requirements for employees over 40, or that attempts to waive claims in ways the law doesn't permit can be challenged or thrown out entirely, which means the business paid severance and got nothing in return legally. The amount of severance offered should reflect what the business is getting in exchange. A clean release of viable legal claims. The amount of severance offered should reflect what the business is getting in exchange, which is a clean release of viable legal claims. An employee who has a strong discrimination or retaliation claim is in a different negotiating position than one who doesn't. Understanding what claims are being waived and whether the release covers them is what determines whether the agreement does its job. Now, how these documents work together. These documents don't exist in isolation. They function as a system, and gaps in one affects the others. A handbook that describes the termination process the business doesn't follow creates a problem that shows up in a separation agreement dispute. An offer letter that implied job security affects the enforceability of an at-will termination. A contractor agreement that doesn't reflect the actual working relationship undermines the wage and hour policy that was written assuming these workers were contractors. The businesses that are best positioned when a dispute arises are the ones that have taken the time to build these documents as a coherent system, one that reflects how the business operates, is reviewed regularly, and is applied consistently. That foundation doesn't prevent every dispute, but it means that when a dispute does arise, the business has something solid to stand on. The problem with online templates. The internet's full of employment document templates, handbooks, offer letters, contractor agreements, and separation agreements available for free or a small fee. For a small business owner trying to get something in place quickly, they feel like a practical solution, but they're worth understanding clearly before you rely on them. A template is a generic document built for no business in particular. It doesn't know whether you're in North Carolina or California, whether your workforce is 5 people or 50, whether your industry has specific compliance requirements, or how your business operates day to day. A handbook template that was written for a retail environment doesn't serve a construction company well. A contractor agreement pulled from a legal website does not account for how North Carolina courts and the IRS may evaluate classification disputes. The other problem with templates is that they reflect the law as it existed when they were written, which may or may not be current. Employment law at both the federal and state level changes regularly. A template that was accurate 2 years ago may reference policies or thresholds that are no longer correct. What an employment lawyer brings to this process is the ability to build documents that reflect your specific business, your specific workforce, and the current legal landscape in North Carolina. More importantly, a lawyer can identify the gaps between what your documents say and how your your business operates, because that gap is almost always where disputes originate. Getting these documents right the first time is significantly less expensive than correcting them after a claim has already been filed.